أهلا بكم. أرحب بكم جميعا للجلسة الثانية. الجلسة الثانية بعنوان التجربة الأمريكية في تنظيم الإعلام. وطبعا أنا متشكر على مثابرتكم ومواصلتكم للمؤتمر. أنا عارف إنه بعد فترة بيحصل للواحد عملية محاولة استيعاب في الأول المادة اللي حصل عليها، وبالتالي ممكن تكون كل شوية العملية بتكون محتاجة تكون أكثر تشويقا، وبالتالي احنا قلنا نخلي الجلسة الثانية بدل ما نعمل أكتر من نموذج فيها نعمل نموذج واحد بس، وهو النموذج الأمريكي، الولايات المتحدة الأمريكية والتجربة الإعلامية فيها بالنسبة لموضوع تنظيم الإعلام أو الريجوليشن، أو بالنسبة لموضوع التعامل مع محاسبة الإعلام أو الإعلاميين فيما يعتبر accountability. الموضوع دوت أعتقد أنه مهم لينا أن احنا نركز عليه. احنا هنخصص له ساعة ونص بدلا من ساعتين، لأن التجربة الأوروبية كان فيه 3 نماذج، لكن أنا أعرف أنه كتير من الأمثلة اللي دايما بنتكلم عنها بتكون متعلقة بالتجربة الأمريكية. التجربة الأمريكية طبعا شيقة في الاهتمام بيها، من حيث ان احنا بنتكلم في مصر، وجزء من حاجتنا لهذا المؤتمر وهذا النقاش هو كما ذكرت في المقدمة انه الدستور الجديد في مصر ما بيتكلمش كتير على الإعلام المسموع والمرئي. إشارة بيتركها للمشرعين، بينما بيدي للصحف المكتوبة الحق والضمان في الدستور المصري الجديد في إطلاق الصحف وإنشاء الصحف بدون عملية ترخيص. لكن بالنسبة للإذاعة والتلفزيون واضح أنه هو بيطالب بأنها تنظم أي ترخص من البداية في الدستور، وتركها ده للقانون. طبعا ده كان ممكن يكون مفهوم في الدستور الأمريكي اللي كان من البداية متحيز للإعلام اللي يعرفه لما اتوضع من 220 سنة، فكان بيتكلم على حرية الرأي وبيتكلم على المكتوب أو المطبوع. طبعا المحكمة العليا الأمريكية، المحكمة الدستورية العليا الأمريكية، حاولت تتلاحق هذا الموضوع وتعالجه في أحكامها المتأخرة، لأنه في البداية كانت أحكام المحكمة العليا الأمريكية بتعطي للصحافة المكتوبة حقوق أقل أو ضمانات دستورية أقل من الضمانات اللي بتديها للإذاعة والتلفزيون. الغريب في الموضوع إنه الضمانات دي كانت في الأول بناء على إنه الإذاعة والتلفزيون مش موجودة في كل بيت. الآن الوضع اتغير وبقى العكس، اللي مش موجود في كل بيت بالضرورة هو الصحيفة المكتوبة أو المطبوعة، لكن اللي موجود في كل بيت هو الإذاعة والتلفزيون. بالتأكيد في اختلافات في التجربة، رغم أن التجربة الأمريكية والبريطانية بيدخل فيما يعرف بالأنجلو ساكسون، لكن رغم كده في اختلاف مهم في التجربة يتعلق بالتطور السياسي لكل بلد. على سبيل المثال تنظيم وضرورة إيجاد رخصة للساتلايت أو القنوات الفضائية اللي موجود في بريطانيا زي ما سمعنا في الجلسة الأولى، ده مش موجود في أمريكا. عايز تعمل فضائية أو ساتلايت، ده يعتبر عمل تجاري طالما في شركة اللي هتديك التردد، لأنه ما فيش مشكلة تداخل القنوات على بعضها. الترخيص بيتعلق بالبث الإذاعي والتلفزيون الأرضي، هو ده التركيز الأمريكي عليه، خلافا للتسهيل اللي موجود في بريطانيا بأنه أي واحد حتى أجنبي مستثمر يقدر يملك وسيلة إعلام إذاعة أو تلفزيون في بريطانيا. بنجد أنه الوضع مختلف بالنسبة للتجربة الأمريكية. كما سيوضح ضيوفنا، في قيود على ملكية الأجانب للإعلام في أمريكا، وده واضح من نموذج مثل روبرت ميردوخ الأسترالي اللي اضطر يحصل على الجنسية الأمريكية لكي يدير إمبراطوريته نيوز كورب أو فوكس نيوز أو غيرها، لأنه غير كده كان يصبح عليه قيود 20% أسهم ليس من حقه التصويت فيها، أي مجرد استثمار ولا علاقة له بها. وبالتالي ربما التجربة الأمريكية للناس المتخوفين من دور أو سطوة الإعلام أو أصحاب الأموال خارج مصر أو من غير المصريين أنهم يسيطروا على إعلامهم، هنلاقي ده في التجربة الأمريكية. دور هيئة الاتصالات الفيدرالية الأمريكية FCC إزاي تطور من فترة لأخرى، وهل هو بيدخل في المضمون أم هو بس بيحدد مين ياخد أي محطة؟ هل ملكية المحطة مرتبطة بأنه مين اللي معاه فلوس أكتر عشان يشتري محطة، ولا في معايير تانية بتحددها الولايات المتحدة؟ ثم كما لاحظنا في الجلسة الأولى لا يوجد شيء سمعناه في التجارب الثلاثة فرنسا وبريطانيا وألمانيا اسمه حبس الصحفيين. أيضا سنجد أنه في التجربة الأمريكية مفيش حاجة اسمها حبس الصحفي لحاجة نشرها أو شيء. احنا سمعنا عن حالة مثل جوديث ميلر الصحفية بالنيويورك تايمز اللي فضلت انها تحبس مش تسجن، تحبس يعني حبس احتياطي لما اعتبر إهانة المحكمة، لأنه أمريكا ما فيهاش قانون فيدرالي لحماية حق الصحفي في عدم الإدلاء عن مصادره. قصة جوديث ميلر في أنه الناس اللي ادوها سواء من المعارضة العراقية معلومات مزيفة عن امتلاك العراق لسلاح نووي، ولما وضع ومطلوب منها مين اللي بلغك الكلام ده، ما كانش فيه قوانين فيدرالية عشان انها تقول ان انا ما اعملش. وبالتالي اعتبر انك لو رفضت الشهادة امام المحكمة وانت ما بتشهدش على الزوجة لانه من حقك ما تشهدش عليها ولا على نفسك، طبعا ضمن التعديل الخامس في الدستور الامريكي لا تشهد ضد نفسك بشكل يجرمك، او حتى بالنسبة لمحاميك الصحفي ما فيهوش حماية، في حماية في الكثير من الولايات لكن الفيدرالي مش موجود. ده اللي خلى القاضي قال حبس احتياطي لانها رافضه انها تقول له مين اللي اداها المعلومه دي، لكن ما فيش حاجه اسمها حبس احتياطي عشان تنشر شيء، في غرامات والغرامه لا تؤدي الى الحبس ان لم تستطع ان تدفعها. انا لا اريد ان ازيد عليكم كثيرا، لكن مهم جدا ان احنا نسمع التجربه من اثنين من ضيوفنا اليوم. هنستمع ايضا من المحامي السيد روبرت كورن ريفر، وهو كبير المستشارين السابق لرئيس الهيئة الفيدرالية الأمريكية للاتصالات FCC، ومحامي له الكثير من القضايا التي كسبها، قضية CBS مع FCC، قضايا أخرى كثيرة من تعامله بالنسبة للإعلام وما للإعلام وما عليه. ده هيكون مهم جدا ان احنا نسمع منه. وايضا انا سعيد انه يكون معانا السيد دوغلاس سميث، وهو منتج برامج ووثائقي بشبكة CBS الامريكية التلفزيونية، خصوصا في برنامجها ساندي مورنينج، اديله اكثر من 20 سنة، حاصل على 4 جوائز إيمي أوورد المرموقة جدا. وايضا سنتحدث ويحدثنا عن تجربة زي محطة CBS اللي ممكن تتخلى عن أحد رموزها الكبار أو الشخصيات العملاقة فيها زي دان راذر لمجرد أخطاء بسيطة بتتم في معلومات في أحد البرامج، ممكن أنه محطة توري الباب لصحفي بالنسبة لها هو إمبراطور في أمريكا، لكن حين يخطئ لابد من محاسبة. نبدأ هيكون في 20 دقيقة لكل من ضيفي، ثم نفتح النقاش والأسئلة اللي انتم تحبوا تناقشوها عن التجربة الأمريكية. وخلونا نبدأ مع السيد دوغلاس سميث في كلمته. تفضل.
Oh, all right, we'll do it. Take 2.
We see TV, not radio.
Let me introduce myself. As a working news producer for a major American television news division, I'm one of those so-called ink-stained wretches that Americans love to hate. In fact, the Pew Center did a poll last year that said that 67% of Americans think news media are politically biased. Reporters Without Borders rates the U.S. in 2013 as only number 32 in its Press Freedom Index, which puts us way behind Finland. Egypt, by the way, is unfortunately rated 158th. Tunisia is 138th. So much for the exalted profession of journalism. All this means that TV journalists in the United States are neither the most respected professionals, nor are they necessarily protected as much as we might think. To be clear about my presentation here, I'm talking from the perspective of an individual news producer. I am not a lawyer, I'm not a network executive, and I do not speak for CBS here. I am giving you my personal reflections on the rules and regulations that shape and protect my profession. In the United States, we like to think of ourselves as the land of the First Amendment. And truth be told, as a journalist, it is something we do keep in mind. Our Constitution's Bill of Rights is the determining text underlying all other laws, and it does have great influence. The text is simple and clear. Quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press. That all sounds clear enough, but in point of fact, Congress has indeed written laws regulating the press. At the national level, broadcast television in the U.S. is regulated by the Federal Communications Commission, the FCC. We'll hear a whole lot more about that. And it has the power to license all television stations. In order to be given permission to use the airwaves, each station must abide by some rules. Essentially, the station has an obligation to serve the interests of the community, and in return, it gets to use the airwaves. Now, the FCC is expressly forbidden to censor anything anyone says. In fact, as part of the free speech protection in the Constitution, it is assumed that programming may be objectionable to many viewers or listeners, and that the FCC cannot prevent the broadcast of any particular point of view. Here I quote the Commission, quote, the public interest is best served by permitting free expression of views. So that's clear, or is it? It turns out there are a number of restrictions on what a TV station can broadcast. First of all, hoaxes are expressly forbidden. If a TV station broadcasts something it knows is not true, and that false information causes harm, and it was foreseeable that it would cause harm, then the FCC will or may intervene. Of course, if the station just puts on a disclaimer and says this is fiction, then no harm is considered to be done. News distortion is not allowed, though since this is usually a judgment call in the eye of the beholder, the FCC does not step in. It apparently gets loads of complaints all the time. The FCC says it does not replace network news judgments with its own. But if it can be proven that there is a rigging or slanting of information to intentionally falsify the news, then the FCC may indeed act. Also, if there's programming that incites lawless action, the Supreme Court has held that the government may curtail speech if it is both intended and likely to incite or produce imminent lawless action. There are also some very arcane rules about how nationally political campaigns have to be portrayed fairly. It used to be under the fairness doctrine, and we're talking national here, national politicians had to be given equal airtime. But this proved to be so difficult to enforce, the rules were changed. Stations had so much trouble keeping track of politicians and giving equal access, they started to duck the whole thing and not have them on. Now the rules call for, quote, reasonable access. And that all politicians must be allowed to purchase advertising time. And then there are rules on obscenity. Basically, obscene programming is forbidden at all times on broadcast TV, not so much on cable TV. How do you know something is obscene? There's a thing called the Miller test, named after a court case called Miller v. California. Something is obscene if, one, the average person applying contemporary community standards would find that it appeals to shameful or morbid sexual interest. Two, depicts or describes patently offensive sexual conduct. Three, lacks serious literary, artistic, political, or scientific value. I encounter this actually fairly frequently in my work because I do a lot of art stories. Interestingly enough, I find that images I used to get away with early in my career, say broadcasting a picture of a naked woman by Renoir, now makes my bosses more nervous. We are much more careful about staying away from any fine lines of distinction. So much so that if we have an image of, say, a line from a novel, we have to carefully look at the whole page to make sure not a single word might be considered offensive, even if the page is on the screen for less than a second. People really do freeze frame the TV image and look for excuses to call us up and vent their anger. So we are extremely careful. Indecent programming is different from obscene programming and is allowed but under constricted rules. Indecency is defined as something, quote, patently offensive as measured by contemporary community standards for the broadcast medium. To protect children from indecent programming, nothing from 6 a.m. to 10 p.m., which is when kids are assumed to watch TV, nothing in that time can be indecent. When indecent events happen, the fines can be in excess of $100,000. Since all my stories fall between the 6 and 10 p.m., 6 a.m. and 10 p.m. time slot, there's really no difference between indecent and obscene. They're both forbidden. And here's one example, just how much of a big deal this kind of thing can be. And my colleague, Robert Korn-Revere, who represented CBS in the case I'm just about to mention, will have a lot more to say about it, I'm sure. But just very quickly, in 2004, on CBS, there was a famous wardrobe malfunction, and the FCC fined CBS $550,000. For those of you unfamiliar with this epic event, in the middle of the biggest, most watched football national championship game of the year, during the halftime break when entertainers come into the field to put on a show, the singer Janet Jackson fleetingly revealed for about 1 second one of her nipples. Frankly, I was watching TV that night, and I didn't really see much of anything. But it created a huge firestorm against CBS for putting on indecent programming. Was this an accident or a deliberate attempt to create a titillating and indecent programming? After complaints flooded the FCC, it investigated and ruled that indeed the wardrobe malfunction was no accident. CBS was fined. CBS disputed the ruling. Actually, I should just skip it, right, and let you, oh, okay, good, all right. CBS disputed the ruling based on the fact that FCC rules were not clear about the very brief images of fleeting nudity. Court of Appeals sided with CBS, and when this in turn was disputed by the FCC, after 8 years, millions of dollars in court fees, the Supreme Court refused to hear the case. And in fact, getting CBS off the hook pretty much on a technicality. The networks, all right. All right. The networks were put on notice so that this kind of fleeting nudity might not be tolerated. One final way the FCC regulates program content, again, to protect children. Certain types of commercials are banned during programs aimed at children. Also, stations have to air at least 3 hours of children's programming per week with less than 12 minutes of commercials per hour on weekdays. A couple of things that I'm not allowed to show in my news reports that aren't, I'm not sure where the regulation comes from. I don't think it's FCC. One, I'm not allowed to show prisoners without their permission. I have to get it, I don't have to get it in writing, but if I'm, as I have, filmed in prisons, I do have to ask them permission, or I cannot use the image. And the other is in hospitals. I cannot show hospital patients. That's due to the HIPAA Act, which is the Health Something Privacy Act that protects all hospital patients. So again, if I don't get their permission, I cannot use the image. There are other types of government regulation. One on a more basic level is the giving of press passes. In the United States, there is no national press authority. I do not carry a national ID card that identifies me as a journalist. In the city of New York and in many other jurisdictions, local police will issue press passes for journalists who cover news that requires them to cross police barriers. I carry a card issued by the New York City Police. And when I was covering the demonstrations by the Occupy Wall Street movement, it was very useful for getting my camera crew around various police barriers. This kind of pass situation can, of course, always be open to abuse. If it turns out you're overly critical of police methods, you might somehow find yourself without a pass. But I should point out that I have never witnessed myself any kind of action like that. I did find, however, that in the days after September 11th, having a press pass was actually a detriment for my work. Police would stop us at barriers if they saw we were credentialed journalists, but if they thought we lived in a downtown neighborhood, they would let us by. This was a very short-lived situation when the police happened to be extremely nervous. But TV is not just regulated by government. Much more important is the regulation by the threat of lawsuit. It's the threat of lawsuits that determines what we do and how we do it every day. There are a number of ways we're influenced by lawsuits. Libel, as the gentleman from, I think it was England who had said, it's not a criminal matter, but rather something for civil suits. Libel, put simply, is the false or unjustified injury to someone's good reputation. One of the most famous libel cases in the US, before it was even the United States and was still a British colony, was in 1734, when in New York, Peter Zenger was imprisoned for writing attacks on the British colonial governor. Zenger's lawyer argued and won on the premise that you can only sue for libel if the defamatory information is proven to be false. In other words, truth is a successful defense against libel. That's what I call a good incentive for accurate journalism. In more recent times, in 1964, the New York Times v. Sullivan case created a national rule for how to deal with libel. Public officials could no longer sue successfully unless they could prove actual malice, showing reckless disregard of whether it was false or not. In other words, it wasn't that the journalists had published false information, but they had published it with malicious intent, a much harder thing to prove. This ruling applied to public figures like politicians, sports figures, and movie stars, who have a tougher standard of libel than just regular private citizens. And again, I heard the same this morning with the Europeans. Public figures have to prove that a journalist has knowingly printed false information while making little, if any, attempt to distinguish truth from lies. Private individuals are protected more stringently because it's thought that protecting their right to privacy may outweigh the right to free speech in this situation. So private citizens can sue for libel more easily and have a lower threshold to prove malice or negligence than do public figures. We had a particularly egregious example of careless defamation of an individual for a story about how doctors might contract AIDS from a patient. Someone used a generic shot from our archives of a doctor treating a patient. The doctor happened to see this on the nightly news and called up and asked CBS not to put his image under that particular narration because it implied that he was infected with AIDS. We apologized, but just a little while later, another news report on the subject came up, and an overworked editor went to the archives, pulled the very same shots of the doctor, put it under the narration. CBS apologized, and when it happened a third time, the doctor sued, and I think he won. The reason I know this story is because in most every presentation on what not to do when editing CBS News stories, this anecdote is brought out. While careless journalism makes you subject to lawsuit, satire is expressly protected as a free speech right. The U.S. Supreme Court has ruled that satire, no matter how scathing, is protected by the First Amendment. Now, there's one lawsuit that consumed CBS for years, which was when a general who commanded American troops in Vietnam during large parts of the war there sued us for libel. Retired General Westmoreland sued for $120 million over a 1982 broadcast that accused him of exaggerating American military progress in Vietnam and conspiring to misrepresent enemy troop strength. He was furious, felt his character was attacked. After a very long, drawn-out legal battle, an out-of-court settlement was reached. Nobody won this libel suit, though both sides claimed victory. The judge did what the law called for and set a high standard of proof that the broadcast was knowingly or recklessly false. Both sides claimed they were right, and it's been left up to history to decide who was the more accurate. It was, however, a very expensive history lesson. Another lawsuit that got CBS a lot of unwanted attention was one of its former anchors, Dan Rather, sued it for $70 million. It was a suit for breach of contract and fraud, but Rather claimed it was to bring out the fact that there is undue political pressure on news stories. It all started when CBS aired a story by Rather about George Bush allegedly receiving preferential treatment while he served in the Texas Air National Guard during the Vietnam War. Some document purportedly written by Bush's commanding officer was shown on the broadcast, but after the show aired, there was such a brouhaha over the piece that CBS was forced to admit that the document might not be able to be authenticated. After that, Rather was allegedly slowly pushed out of the anchor chair, and several producers, including one of my friends, lost their jobs. The courts forced the issue of the specific suit to be narrowed down to whether Rather's contract had been breached, and ultimately ruled against Rather. While I don't want to imply this was a frivolous suit, it does show how the threat of very expensive suits can be chilling on a news division. Much more common are suits that deal with copyright infringement. Because the show where I work uses a lot of archival video and photos, we're always dealing with issues of what's called fair use. In a nutshell, we can use video clips from films without the permission of the copyright holder. If the clips are short, say under 11 seconds, and are meant to illustrate an editorial point that could not be shown another way. The relationship of the clip to narration is essential to proving fair use. One thing that's clearly not a fair use is using a clip just for its production value, as distinct from its editorial value. Photographs are different, and we usually do not use photographs unless we can reliably find their owner and arrange for their permission to use it. Just anecdotally, one famous photographer's work was used 3 times in a very short time on our show without notifying her, and she sued us for, I think, about $30,000. So to avoid lawsuits, CBS has very clear rules and standards. As we discuss media regulation, I think it's important to think about journalism that has a certain cultural standard that might not really be subject to legislation. And I heard this earlier, the Europeans mentioned it too, the culture of journalism. Where I work, there's a very real effort to inculcate a culture of professional journalistic standards. One of the defining qualities of that standard for television journalism is that what you see on the screen is what you say it is. Just applying that rule gets you out of a lot of jams where you might be tempted to use some kind of visual shortcut. Our viewers can be pretty sure that what we tell them they are seeing is what we say it is. Now, this can get a little tricky when you get into the nitty-gritty of what a particular video image implies. But in general, with some thought, you can avoid being misleading. The point, obviously, is to be honest at all times. That's something that's hard to legislate, but very important to instill in journalists who sometimes get so carried away in the arguments they're trying to convey, they may resort to unacceptable shortcuts. One of the major tools for avoiding lawsuits and creating a better environment where I work personally was when we appointed one of our producers as an independent fact checker. Before that, I was always paranoid that someday at midnight I would be writing or editing something in a hurry and it would turn out to be desperately wrong or inaccurate. And an objective fact checker is an effective institutional way to provide a second line of defense, to avoid costly mistakes, maintain high journalistic standards. Another aspect of the culture of journalism that perhaps can't be legislated but remains a central regulatory mechanism is the need for skepticism. If there's a quality shared by all good journalists, it's healthy skepticism towards what all sources tell you. In a world in which conflicting opinions are the rule, skepticism towards all is a useful virtue. As some journalist once said, if your mother says she loves you, check it out. In the US, we sometimes tend to think of the search for truth in the light of how it's done in the courtroom. We've all seen the TV and movie dramas where prosecutor and defense give their version of reality. Sometimes truth does emerge from this conflict of divergent opinions. Sometimes it doesn't, or causes us to be too respectful of one version over another. When I started this talk, I mentioned how important the First Amendment was to us American journalism. But what I also see is that the marketplace is increasingly being used to define what is a news story. It used to be that in the US, news divisions were seen as necessary financial losses that stations accepted as part of their original responsibility, and of their social responsibility, in return for the privilege of being able to put their signal on the airwaves. Now all news divisions are subject to very real cost constraints and are expected to pay for themselves. Stories are not censored by government bureaucrats. Instead, a story's popularity might define if the story is told at all. Does this mean that unpopular ideas are not covered? Perhaps. I feel there is a new kind of censorship, not about what we say, but what we don't say. We have been strangely quiet about a great many stories that are felt to be not popular, so we don't cover them. Keeping up a clear wall between fundraising sources and editorial control is, of course, primordial. Whether it's public television stations being beholden to contributors or private stations beholden to advertisers, there has to be a very clear separation between those who have editorial news judgment and those who keep the purse strings. This sounds blindingly obvious, but it always bears restating. Any efforts to come up with good legislation to regulate media needs to take into consideration the non-legal ways journalism can be controlled. Specifically, the chilling effects of lawsuits needs to be part of any dialogue, and considering ways to limit frivolous, or what's come to be known in the US as SLAPP lawsuits, should be part of the discussion. SLAPP is an acronym that came up in the 80s and stands for Strategic Lawsuits Against Public Participation. These are lawsuits that are intended to censor, intimidate, and silence critics by hitting them with lawsuits that are expensive to deal with. I have no personal experience with these SLAPPs, but just want to mention both their existence and the fact that in the US, states like New York and California have come up with anti-SLAPP legislation that essentially shortcuts the process by having a judge review the suit at the beginning, and if he or she feels there's no chance of winning, in fact, is only being done as a harassment tactic, then the judge can throw it out right at the outset and even award punitive damage costs. In conclusion, any conversation about media regulation has to circle back to self-censorship and how we as journalists can be affected by various pressures to blind ourselves to stories, to feel they are not stories at all. Of course, this is part of news judgment. We as journalists are not only called upon to report the news, but to define what is the news. Watchdog groups and polling groups like the Pew Foundation help us be more self-aware. Independent foundations are an important part of the process of keeping journalism free. Our First Amendment to the Constitution has been critical to protecting free speech, but so is promulgating a culture of professional, skeptical journalism that effectively critiques itself as it seeks to maintain high journalistic standards. Thank you.
شكرا للسيد دوغلاس سميث. في الواقع العرض كان في 25 دقيقة، وده أيضا الوقت اللي هنديه للسيد روبرت كيرنرفير لو هو حب يمد عن 20 دقيقة. ومهم جدا ان احنا نسمع ايضا وجهة نظره، خصوصا في قضايا مهمة طرحها السيد سميث المتعلقة بالمعايير المهنية اللي كتير جدا من العمل بيتطلب انه الوسيله الاعلاميه نفسها تضع لنفسها كمعايير، بالاضافه طبعا لاشياء اخرى كثيره. لكن ايضا مهم جدا التوضيح بانه احيان كتير بيكون التجربه متعلقه بالردود الفعل، يعني مساله قد ايه الناس ممكن تتضايق وتضغط عليا بقدر ما هو أكتر من مسألة إذا كان في رقابة حكومية، بمعنى أنه المحطات اللي هي حريصة على الجمهور بتاعها، الناخب، المعلن، غيره، أحيانا بتعمل عملية تنازلات أو رقابة على ما لا تقوله عشان ما تضايقش الناس، لكن ده اختيارها هي، مش لأنها ما بتقولوش أنه القانون يمنحها أنها تقوله، لكن ده يعتبر قرارها هي أنها تعمل كده. أيضا موضوع الفير يوز موضوع لطيف جدا، لأنه أنا أذكر في بعد سبتمبر 2001 11 سبتمبر بصينا لقينا لما حدث الحرب الأمريكية على أفغانستان في 7 أكتوبر 2001 مرة واحدة كانت جزيرة وكنت بعمل معها ساعتها موجودة وبتنقلها 3-4 محطات أمريكية كله بترجمة، بس بيجيبوا حد مترجم لأنه كانت الجزيرة الوحيدة اللي عندها محط فيديو ساتلايت من كابول لما قامت الحرب. فساعتها سألنا هو الناس دي ما وقعوش معانا عقود؟ مش في حاجة اسمها فير يوز؟ والواجب ده أقصى حاجة دقيقتين ويكونوا 10 ثواني متقطعين بعيد عن بعض. فقالوا لنا يعني فير يوز للامريكان يعني، لكن فير يوز ليكم روحوا شكونا بقى. فطبعا بالنسبه لمحطه عربيه كانت سعيده انه الناس تنقل عنها، وكان ده الجزء الأهم. لكن اللي أنا بقوله إنه أحيانا اللي بيحدث في العمل شيء والواقع شيء آخر، لكن المعيار الرئيسي فيه الناس بترد ولا ما بتردش. ودي أشياء كتيرة أحب أيضا نبقى نناقشها في النقاش، زي هل بس المحبوسين أو المسجونين والمرضى ما نقدرش نصورهم؟ ماذا عن القُصّر والأطفال الماينورز مثلا بالنسبة لتصويرهم والحقوق؟ ماذا عن حالات أخرى كتيرة مطلوب مننا أن احنا نعرف مواقف عنها؟ الآن الكلمة للسيد روبرت كورنريفير، فليتفضل.
Well, first I want to thank the American University and Hafez Al-Marazi for inviting me to speak at this very important conference. It is particularly an honor to be here at this time of great transition throughout the Middle East, but in particular in Egypt, and to talk about the American experience in dealing with media and our legal system. And let me be clear, I'm here to discuss the experience that we've had, but not in a prescriptive way to suggest you should adopt one thing or another, but rather to simply describe our experience and hopefully go through some of the lessons that we've learned from it. And if you have questions, I'll be happy to address those as best I can. I also want to make clear that I'm not here to speak on behalf of anyone, and also to make clear I'm not here to speak on behalf of any particular perspective. I've worked in the American media system as a reporter before law school. I then worked as a regulator at the Federal Communications Commission, and now I'm a practicing lawyer, where quite often I find myself opposing the government in its efforts to restrict expression in one way or another. And so having seen it from those various perspectives, hopefully I can present a broader range of views and perspective than I might have if I were just here from the FCC. I will talk about our regulatory structure and a little bit about how it works, but it's important to know that the regulatory structure is not where the American story begins, and it's not the source of our basic law. As has been discussed since the opening panel, and Douglas Smith just talked about it, it really begins with the First Amendment to the United States Constitution. Now, I am acutely aware that when Americans talk about the First Amendment in international gatherings like this one, we're really just talking about a local ordinance. This isn't something that applies globally. It's something unique to the United States, although other systems certainly have their own protections for freedom of expression. This is the one that was adopted at the beginning of our country, adopted in 1791 following the American Revolution. And Douglas read you the words of the First Amendment, but it's difficult to appreciate just what that means just by hearing those 45 words. They essentially set forth 5 specific freedoms: freedom of speech, freedom of press, freedom of religion, freedom of assembly, and freedom to petition the government. And each of those areas of law has been developed through specific case law through American history. Now, many of those protections were adopted based on previous experience. Douglas mentioned the John Peter Zenger trial in 1735, which was essentially a seditious libel trial, a libel against the government. And in that case, based on the arguments made by the lawyer Andrew Hamilton, the jury came back with the finding that truth, in fact, is a defense to a libel claim. Before, it had been exactly the opposite. The more true the criticism of government, the more libelous it was considered to be. And therefore, it was a revelation in the law to recognize that truth could actually be a defense. And that was one of the underlying historical developments that helped form the First Amendment when it was adopted by the framers of the United States Constitution. It is interesting to know, too, that the First Amendment, even though it was adopted in the 18th century, was really not developed until the 20th century. As I mentioned earlier, it was developed largely by case law, but there were no cases interpreted by the United States Supreme Court until the 1920s, or just before the 1920s, that really began to interpret what that basic charter meant. And in fact, there were no cases upholding First Amendment rights until around 1930. And so it largely is a 20th century phenomenon and one that is still developing. The 20th century also was the birth of the regulatory state, where we began to see various laws adopted by Congress to try and take control of the new media, primarily broadcasting, but also telephones were developing at the time. But one of the things that I wanted to talk about is the way in which technology and censorship and technology and regulation have always been combined. They have always gone hand in hand. As a matter of fact, it's a paradox that both freedom and censorship are products of technology. There really were no censorship boards before the printing press. There was really no need for one. Books were written by scribes under the control of the church, and so you didn't need any organized forms of censorship. It was only once you had technology that created the possibility of the mass dissemination of information that there was a need for a governmental response, and that response took various forms. It took the form of either state control of the press or state monopolies being granted by the government, press monopolies being granted by the government. It also took the form of the Court of the Star Chamber, which was, in essence, a censorship board. And we saw this reaction to technology occur time and again, not just in England and the United States, but worldwide. In 1906, for example, Turkey banned the importation of typewriters because it found that it allowed people to type things and they couldn't necessarily be identified, and so this was seen as a threat. At the same time, technology inevitably overcomes efforts to control it. As I say, the First Amendment was adopted as a way of embracing the technology of the press, but long before that, the institutions that England had adopted to regulate the press had died away. The Court of the Star Chamber had been relegated to the dustbin of history, for example. As other technologies began to take hold in the United States, we saw similar cycles come and go. When cinema became a phenomenon in the early part of the 20th century, almost instantly various state governments adopted censorship boards. They thought that this technology was inherently dangerous. It was a commercial product that could affect public morals. And so many, if not most, jurisdictions had these boards to review films before they could be seen in their communities. Over the years, as case law developed and First Amendment protections were extended to things like cinema, over time those state boards faded away. They were largely gone by the 1960s. But the last one existed in the United States up until 1991 in Dallas, Texas. And so even where there is legal change, it takes time for those changes to take root. Now, as I mentioned, the 20th century saw the birth of the regulatory state, and because of that, or largely is because this is when we saw the birth of electronic media. And electronic media presented a particular problem. As broadcasting was developed in the 1920s, it was developed as an unexpected and therefore unregulated medium. And people were simply putting up radio stations in their garages, much like internet entrepreneurs are today. As a result, there was chaos. People would broadcast on each other's frequencies. It became very difficult to hear anything because everyone was speaking at once. And so over a period of years in the 1920s, Congress tried to take some sort of action to regulate the press, or regulate the broadcast press, that is. It was inherently difficult to do because the problem was a political one. No single political party in America wanted to give control to the opposite party to this new medium, and so Congress was pretty much deadlocked over what to do for a number of years. Sounds very contemporary, doesn't it? The first law was ultimately adopted in 1927, the Radio Act of 1927, to regulate commercial broadcasting, and it set up a system of licensing. This was quickly followed by the Communications Act of 1934, which consolidated the various regulatory structures for communications. It included telephony and broadcasting, and put them all under the control of the Federal Communications Commission. Now, that law is still our basic law that governs broadcasting and other forms of communications. It has been amended at various points in our history to take into account different forms of communications, but it still remains the basic law that we follow. A little bit about the structure of the FCC. It presently has 5 commissioners. When it was created, it had 7. That was changed in the 1980s. The 5 commissioners are appointed by the President, confirmed by the Senate, and by law, no more than 3 of the 5 commissioners can be from any one political party. So while the President can appoint 3 commissioners and have a majority on the commission, presumably of his or her own party, then there can't be an overwhelming control. There will always be commissioners from the opposing party. The FCC is described as an independent regulatory agency. That is, it is intended to operate independently of the executive branch and independently of Congress, and yet it also is under the control of both. Through the appointment power, the President essentially selects people to run the agency. The chairman is appointed by the President. And the only authority that the FCC has is authority vested in it by Congress. That is, Congress adopts statutes like the Communications Act and other amendments to the Act, and then the FCC has the authority to enforce those laws and to adopt regulations in furtherance of those laws. Broadcasters are licensed for a period of years, and this is based on their use of the electromagnetic spectrum. And so the license conveys the ability to do that for limited periods. Currently, it's a 7-year license, and then there are, contrary to what you may have heard, there are still some ownership limits on how many outlets a single entity can own. There are certain content regulations, as Douglas was talking about. For example, regulations that do affect political broadcasting. There are the so-called equal time requirements, or more accurately, equal opportunity requirements, that require that if a person in a particular race uses a broadcast facility either with free time or paid time, the opponent of that candidate has the ability to purchase or receive an equivalent amount of time for use. There are also, and separately, the reasonable opportunity requirements, which apply to federal candidates, which simply require that broadcast stations must sell reasonable amounts of time to candidates for federal office. There are the Indecency Regulations, as you've heard, which are separate from Obscenity Regulations, which are well, problematic from a number of standpoints, but I'll get to some of those differences. One of the problems is that the FCC's regulatory authority for these kinds of regulations extend to broadcast stations, but not to other media. And that makes them spectacularly ineffective and have never been very well enforced or very effectively enforced, even when they've been harshly enforced. But again, I will get to that. Now, as I mentioned, these regulations have grown up separately with different technologies. And in fact, in our history, as new technologies have developed, the government and courts have struggled to find ways to adapt our basic constitutional structure and apply it to those new technologies in ways that make sense both under the statutes they adopt and also under the Constitution. It helps to begin with an understanding that the regulatory structure that was adopted is itself a paradox. We have a constitutional system that was developed in reaction to press licensing and said that newspapers will never be licensed, and in reaction to government attempts to control the press. And yet in the 20th century, even as the First Amendment was being developed by case law, we saw the development of regulatory structures that adopted exactly the opposite paradigm, where you can publish a newspaper without ever having to approach the government for permission. You cannot broadcast without having a license from the government. while you have newspapers that aren't subject to government control and don't have to worry about censorship and don't have to worry about not just prior restraint, but even being punished after the fact, except for certain common law issues that Douglas referred to. With broadcasting, you're constantly facing those kinds of pressures because regulations exist for broadcasting that do not exist for traditional media. So as additional technologies have been developed and courts have extended First Amendment protections to them, we have found a particular mismatch in the way we apply our constitutional system to new technologies. As a matter of fact, the courts traditionally have been reluctant to extend First Amendment protections to new media, but over time they have begun to do so. A good example of that is cable television. Cable television developed slowly beginning in the 50s and 1960s. The FCC began to adopt some regulations of cable television in the 70s. Congress finally got around to adopting the first legislation dealing with the regulation of cable television in the 80s. And then the courts finally in the 90s began to try and develop some sort of constitutional framework for how to treat cable television. At first, regulators sought to apply the same kinds of regulations that we had had for broadcasting to cable, because after all, both of them used the television set as the entry point into American homes. But they used fundamentally different technologies for transmitting the signals to the television set. And it was the technology of using electromagnetic spectrum that had been the regulatory hook for regulating broadcasting. Cable didn't have that same regulatory justification. What it had was justification through local land regulation. And so you would have local governments involved by granting franchises for putting up a cable system. But you didn't have a system of federal licensing. Finally, though, beginning in the 1990s, the Supreme Court extended full First Amendment protection for cable television. And in a case that I argued in 1999, finally said that you cannot apply content regulations that you would apply to broadcasting to cable television. All of this, by the way, is very confusing to the viewer, which really doesn't distinguish between a cable channel when they are cruising television with their remotes and an over-the-air broadcast channel, but they are regulated differently. And then finally, we have the technology of the internet, which came along catching the government largely unawares in the mid-1990s. It actually began before that, but the web really hit the world around 1994. And as a result, the first impulse of federal regulators was to try and regulate it like television. They adopted as part of the Telecommunications Act of 1996 a provision called the Communications Decency Act that sought to impose broadcast-type indecency regulations on the internet, thinking, I guess without looking into it, that the broadcast regulations were working just fine. But that ultimately went to the United States Supreme Court in 1997. And it held that those regulations could not be applied constitutionally to the technology of the internet. And this was a historic moment because for each technology as it came along, it usually took time. It took decades before the court would get around to catching up with the technology and deciding whether or not the First Amendment, as it's understood traditionally, as it's understood for the press, would apply to these new technologies. It did after about 4 decades for cinema. It did after about 3 decades for cable. But for the very first time, when the internet was, there was an attempt made to regulate the internet as if it were television. For the very first time, the Supreme Court, in its very first case, looking at a new technology, held that you could not apply these new regulations to the internet. And it said there is no reason to treat this technology differently than you would traditional media. That was really a watershed moment in American law because, as we've seen, as technology has evolved, we now are in the age of convergence, where all media are intertwined. They are using many of the same platforms. Television shows are delivered over mobile devices. They're delivered over computer. You know, the broadcast regulations that we think are going to protect our children really are irrelevant in a world in which we have converged media. I'll give you one example. The indecency regulations that prevent broadcasters, over-the-air broadcasters, from transmitting material considered to be indecent between the hours of 6 a.m. and 10 p.m. may have made sense in a world in which that was the only way you consumed broadcast programming. In a linear fashion, during the day, you would turn on the television and you watch it in real time. But in a world in which you can receive the same programming on demand on your mobile phone, or you may have a digital video recorder, so you watch the program regardless of channel and regardless of time, whenever you choose. Having a regulation that tries to protect children by time channeling makes no sense whatsoever. And so just as it was with the printing press, where the technology ultimately overrode the attempts to control it, the same is true for electronic media, whether it's broadcasting or cable or the internet, despite whatever attempts may be made to ultimately exert control. Ultimately, the technology is what will shape what we can do with it and what its capabilities are. This has also had profound implications for the business world, by the way, for those who are worried about conglomerate control of the media. Has anyone looked at what's happened to the advertiser-supported media world in the last 5 or 10 years? It is struggling for survival. Major newspapers in the United States have gone under because people can get their classified advertising online and for free. The economic drivers of those media have been undermined by the fact of, quite frankly, the democratization of media. Those pressures that exist on newsrooms exist not because of anything other than the fact of the changing economics of the news business, so that companies that were once considered to be invincible are now again struggling for survival. So it's a revolution that's affecting not just the world of regulation, it's affecting the world of media as we know it. And at the same time, while we've relied on regulations to make for a diverse media and all of that, we now have more voices, more capabilities for more people to speak than any time in our history, a time that was unimagined in our history as the time those regulations were being formed. In my experience, and I'll conclude with this, my experience has been that as we've seen media develop, more gains have been made for the public interest, despite regulation and not because of it. While at the FCC we attempted to make sure that broadcasters had a diverse range of programming, that was developed by the market, by cable and satellite channels that provided more diversity than any broadcaster ever imagined. And while we tried to provide access for people to be the speakers and not just the passive recipients of information, that happened without regulators even looking, with the development of technologies like YouTube. And so the world has changed, not because regulations willed it to change, but because they couldn't stop it from changing.
شكرا جزيلا. Thank you both. شكرا جزيلا. طبعا هفتح المجال ناخد أسئلتكم واللي هيجاوبوا عليها مرة واحدة إن شاء الله. الضيفين هيكتبوا النقاط الرئيسية اللي ممكن تكون متداخلة أو يحبوا يعلقوا عليها، ومنها أيضا أسئلة مني في الواقع عن هل يمكن للإف سي سي أو هيئة الاتصالات الفيدرالية اللي بتدي الرخص إنها تسحب رخصة من محطة إذاعية أو تلفزيونية لأنها انتهكت موضوع الديسنسي أو أي حاجة من القيود اللي محطوطة عليها أم لا؟ فعليا مش بس كمان من الناحية النظرية هل ده بيحصل؟ المحطات اللي هي pay per view على سبيل المثال، المحطات اللي هو بتتفرج عليها بتدفع لها عشان تتفرج عليها إيجار مبلغ شهري، هل المحطات ديت اللي فيها سبسكريبشن من حقها تحط إعلانات تجارية وهي أصلا بتاخد مني فلوس كل شهر عشان أتفرج عليها؟ وهل في قيود على عدد دقائق الإعلان التجاري الموجود؟ دي بعض الأسئلة اللي من عندي، وهفتح المجال لو أي حد منكم عايز يسأل. انا عشان بس اخد يعني اتحرك كده الناحيه دي وبس يعرف نفسه ويتفضل يسال السؤال. الناحيه دي في حد؟ اوكي، على الشمال مفيش. اوكي، على اليمين دكتور بسيوني اتفضل.
Thank you, Mr. Hafiz. Well, it was Thomas Jefferson in 1800 who said that if I would choose between a government without media or media without government, I would choose the latter. Okay, or the latter. Now, with the evolution of media freedom and the violation used by the journalists and media people, it was the commission of media responsibility. The dilemma here in Egypt is the contradiction between understanding the balance between freedom of information and the journalism on one hand, and responsibility of media people and journalists on the other hand. These are the two extremes in Egypt nowadays. And there is no, in fact, middle ground between. Because politicians may look at the freedom as, or the free people as irresponsible people if they criticize them. On the other hand, the journalists see themselves as fully free without any kind of limitations, be it political, social, economic, legislatives, and so on. My question, simple question is, or important question is, how to create some sort of balance between these two extremes, and this is the dilemma. Secondly, we are engaged now in acting or issuing the law of information freedom or act of freedom of information. There is also a conflict of interests between national security and secrecy. How to create a balance between the exceptions from transparency, exceptions that protect national security and harms of economy and so on, on one hand, and transparency and the right to know on the other hand. Finally, in 1 second, most protections are given in the United States for children, and this is the right to protect children and adolescents from. And the comparison is unfair between the United States and Egypt because the level of illiteracy in Egypt, for instance, is more than 40% for women and about 25% for men. Children protection is not a matter of age, it's a matter of the ability to choose from among different things that may harm childhood. We have more than 40% of illiterate people that may need more protection and more laws to protect them from the abuse of media freedom. How also we can create a balance between freedom and protection of illiterate people who cannot choose from different viewpoints. Thank you.
دكتور صفوت عفوا اتفضل. دكتور حسن رفعت ايدك عفوا. طيب بعد دكتور صفوت.
بسم الله الرحمن الرحيم. صفوت العالي من كلية الإعلام جامعة القاهرة. يعني من الواضح أن كثير من آليات التطور التكنولوجي أثرت كثيراً على أساليب المراجعة والرصد لكثير من الممارسات الإعلامية وخاصة وسائل الإعلام الإلكتروني. وبالتالي هناك جانب يمثل درجة كبيرة من الخطورة في كل المجتمعات وليست المجتمعات النامية فقط. أنا أتصور أن كثير من عوامل ووسائل التطور التكنولوجي تسير بسرعة فارقة تتجاوز بمقتضاها درجة تطور البنية التشريعية التي تلائم التطور في وسائل الإعلام الإلكتروني. وبالتالي السؤال المطروح حول مدى قدرة التشريعات الإعلامية في دولة زي الولايات المتحدة الأمريكية على ملاحقة التطور التكنولوجي في التعامل مع وسائل الإعلام الإلكتروني. هناك جوانب أخرى أيضاً تطرح نفسها خاصة وقت الحملات الانتخابية، خاصة وأن تجربة الانتخابات الرئاسية الأمريكية وتنظيمها من الناحية الدعائية والإعلانية يمثل نموذج لكثير من الدول، وبالتالي القواعد الأخيرة التي تم بمقتضاها تنظيم عملية تمويل الحملة الانتخابية حتى يمكن الاسترشاد بها في مصر، خاصة وأن كثير من تجاربنا في الانتخابات الأخيرة وفي الانتخابات النيابية تحظى كثيرا بكثير من الانتقادات. شكرا.
تفضل.
شكرا جزيلا. يعني في إطار الاستفادة من التجارب الدولية وإحنا بنشوف النموذج الأمريكي، الحقيقة يعني في 3 حاجات أنا عايز مزيد من الضوء حواليها. نمرة 1 تشكيل الاف سي سي، مكوناته وشروط الأعضاء أو مجلس إدارة. الحاجة الثانية شروط الترخيص بتبقى طبقا لإيه. النقطة الثالثة والأخيرة عايزين نشوف التعامل مع الإنترنت أخباره إيه، لأني يعني ده عصي على يعني وضع قواعد ليه. شكرا جزيلا.
شكرا جزيلا. أسئلة مهمة جدا لينا جميعا. أستاذة شهيرة تفضلي. أنا أعتقد أنا برجع بعد كده الناحية دي إن في الأستاذة فريدة والدكتورة ميرفت.
My question is for Mr. Smith. I'm really fascinated by the story of the journalist who wouldn't reveal her source and chose to go to prison. In 2011, I came under immense pressure to disclose my source. I had gotten an admission from a senior military general that they had performed the virginity tests on the female protesters. And I didn't reveal, he had spoken to me on condition of anonymity, of course. I didn't reveal his name in the story, but then there was a public uproar and I was accused of being a liar. One of the protesters filed a lawsuit and it would have helped her in the case to reveal his name. So I want to know what is ethical in a situation like this. Would you shield your source or would you help bring the perpetrators to justice by revealing his name?
أستاذة فريدة تفضلي.
أنا استوقفني في الكلام اللي قالوه الأساتذة كلمة تشويه شكل المعلومة. فأنا بس برصد بصفتي اشتغلت شوية بالإعلام، برصد إن من أكبر رموز أو من أوضحها تشويه المعلومة مثلا لما اتحرق ملجأ العامرية وطلع في الإعلام الأمريكي إنه في أصبنا مثلا صاروخين و3 طيارات وهدف جانبي، يعني 380 عراقي بقى اختصروا في إنهم هدف جانبي هامشي يعني كده. يعني عايزة أقول كمان إن الإعلام الغربي ما ساعدش المنطقة بتاعتنا في إنها تلاقي المعيار الصحيح، لأنه كل حاجة كانت بتجيلنا مسقوقة. مثلا الحزام الأمني في جنوب لبنان اللي هو الشريط الحدودي اللي إسرائيل بتحتله في جنوب لبنان، بس لازم نقول حزام أمني. إن إحنا نيجي مثلا نلاقي إن إسرائيل موتت 20 إرهابي، نلاقي منهم 18 طفل دون السابعة. إن إحنا نلاقي مثلا إنه ليبرمان اللي هو أفيجور ليبرمان بيقول اهدموا السد العالي، فإحنا إذا قلنا مناخيره وحشة نبقى إحنا اللي إرهابيين. في كمان إن تقييم الحكام العرب بيتم على أساس علاقتهم بالنظام بالأنظمة الغربية وليس بشعوبهم، وعشان كده الناس بطلت تصدق إن الغرب وخصوصا الولايات المتحدة الأمريكية مهتمة بحقوق الإنسان. بضرب مثل كمان دلوقتي عشان ما أطولش، اللي بيحصل في سوريا. اللي بيحصل في سوريا أيا كان اختلافنا معاه، في طرفين بيتنازعوا وفي طرفين بيقتلوا بعض، ومع ذلك بنلاقي النظام السوري قتل 100 قتل 200، كأنه الناس اللي بتحارب النظام السوري كأنها مش مسلحة، كأنها قاعدة مربعة ايديها كده ومستنية الضرب. فأنا بس عايزة أقول إنه تشويه الصورة لما أنا ألاقي لما بيقولوا لي على الإرهابيين الفلسطينيين اللي بيتقتلوا ألاقي فيهم أطفال مرميين في الشارع وممزقين الجثث، ومنهم يعني ساعات بيبقى فيه رضع فأنا عايزة أعرف إنه هل إحنا مش كلنا محتاجين برضو نعيد النظر سواء في المصطلحات أو في التوجه، وعلينا إن إحنا نفتكر إن الإعلام هو كان سبب وقف حرب فيتنام طبعا غير المقاومة الفيتنامية. شكرا.
شكرا جزيلا دكتورة ميرفت. بإذنكم أنا هاخد كمان 2 وعشان يبقى في وقت للإجابات، وبعد كده الساعة 3 احنا عندنا الغدا في قاعة عايدة في نهاية الكوريدور دوت عشان نقدر نلحق نرجع للجولة العربية الجلسة العربية الأخيرة. عفوا اتفضلي.
Okay, my question is regarding, first of all, it's to Mr. Douglas. Regarding the lapse, the lapse and the lapse criteria in regards to obscenity, and the fact that it is very relevant. So if we are not even, it's a very local criteria to define. If we cannot really make control of the lapse criteria in determining what would be obscene and not obscene in traditional media, how are we going to handle this in terms of the internet or new technology, or how are you aware? I'm sure you're aware, but are there any measures that we're following to try to contain what lapse is, because anything can be artistic or literal or political or scientific regarding an excuse to say, wallahi, this is my way of being artistic, to pose naked or something like actually issues that had happened in our internet with the youngsters in our community. So again, how can we contain this? This is the first question. The second question is a simple question regarding the SLAP and the anti-SLAP discipline. How, to what extent they are being exercised in the United States? Are they very common or not? Thank you very much.
شكرا جزيلا. عفوا أنا مش شايف كويس في الأستاذ صلاح.
Yes, my question is about the restrictions you talked about in regard to news distortion. I think it's very relevant to people here in Egypt because not only do many Egyptians feel that the content is very much distorted from the external international media in the last 2 years, in the last 2 weeks actually, where a tremendous amount of time is given to a dozen or 2 people that are throwing Molotov cocktails, and around the corner, just 2 minutes walk away, there's 500,000 peaceful demonstrators in Tahrir who get very, very little coverage. And this is throughout the international media. I'm not pointing fingers at any one network, but many of them are doing this. And having worked in the media both here and in the US, I've seen this myself in the US. I was on the storyboard desk when the LA riots exploded 20 years ago, and a young producer was calling out the orders for the noon news slot and made a choice to throw up a graphic. We were feeding KCAL to CNN, and he threw up a graphic that showed all of LA County in fire. You know, just based on 3 police reports that there was no verification of whether these 3 reports were connected to the verdict whatsoever. There was a big fight in the newsroom. This young producer did it anyway. He got an Emmy Award for his coverage of the LA riots. And this was, that was the beginning of the end of my corporate media career. I was so disgusted by what had occurred and saw this many times. What can be done? What can be done in regard to news distortion? Since much of the media is not self-regulating, and is not doing, I know many people are extremely professional, but it only takes one bad producer to actually create a riot. You know, this riot in LA, after CNN fed it all over the country, expanded to New York and Brooklyn and Chicago and on and on. So that's my first question. My second question, how can Egypt prevent this from occurring? And my second question is in regard to, you talked about how in the US, political campaigning used to be equal, all candidates used to get the same amount of time, and it became too difficult to regulate. And so you kind of, the US did away with it. Why? And how come the Europeans are still able to do it? You know, if the Europeans can do it, and how can Egypt do it? I think it's extremely important to democracy to have this.
شكرا لك.
Those are my two questions.
شكرا. السؤال الأخير أستاذ صلاح تفضل.
شكرا. سؤالي موجه إلى السيد دوغلاس سميث من CBS. راجت أطروحة خلال الحرب الثانية على العراق مفادها أن الأخبار التي قد تمس بالأمن القومي للولايات المتحدة يجب حجبها. فهذه الأطروحة راجت في الصحافة الدولية بقوة، المكتوبة والمسموعة كذلك. ما هو مصير هذه الأطروحة وما هو أثرها حقيقة على صدقية الخبر المعلن والذي يمس بإمكانه أو يحتمل أن يمس بالأمن القومي، وما هي أثرها في التجربة الأمريكية ونعلم أنها رائدة على يعني أخلاقيات المهنة، علما بأن السيد رئيس الجلسة السيد حافظ المرازي سبق أن عرف ربما نفس التجربة في سياقات أخرى سنة 2011 فيما أذكر. شكرا.
ناخذ إجابة من ضيفينا. يمكن الوقت المتاح لنا الآن أقل من 10 دقائق، لكن الأسئلة مهمة جدا، وأنا أحب الحقيقة أبدأ بسؤال للسيد روبرت بالنسبة لشروط الترخيص بشكل عام، يعني بالنسبة للإذاعة والتلفزيون، بناء على اللي معاه فلوس أكتر عشان يشتري محطة، ولا بناء على إيه، ولو معايير عامة يعني.
The criteria for getting a license basically require the licensee to be qualified financially, meaning that he has to show that there will be sufficient finances to make sure that the station can operate with sufficient funds so that it doesn't go out of business. There historically had been a number of criteria that were used on a comparative basis, and then there would be an opportunity for those who wanted to compete for that license to put in their own proposal, and then the FCC would hold what were known as comparative hearings to compare the qualifications of one candidate against another. There haven't been, since the period of granting broadcast licenses, since the number are limited, has really come to an end. I mean, most licenses now are for existing stations that have been in operation for a number of years, and so you will see an owner then transfer the license to another potential owner. But in that situation, you don't have a comparative hearing or an FCC review, other than to make sure that the licensee who receives, or the potential licensee who receives the station, is not disqualified either by foreign ownership or owning too many other media outlets, and based on that review, then the license will be transferred.
I will let for you whatever you want to answer from the questions we did here before. Yeah. Sure.
Maybe we'll work backwards here. During the Iraq War, sorry, I did not cover the Iraq War. I don't know anything about the national security, whether that was an issue. I just don't know. You know, we did have a lot of correspondence embedded. The decision was made specifically with CBS now to put embed correspondence with military units, which gave us access to events. But of course, it colors. You're at the mercy of then the government spokesman and the, you know, the military PAO office, public affairs officers. The limitations are blindingly clear, and we do try to have other sources, but yeah, we did embed our correspondence in that way. Of course, American correspondence being on the other side in Iraq, you know, during the bombing was fairly risky business. Although, you know, just 2-3 days, maybe 1 week before the beginning of the war, we had a very long interview with Saddam Hussein. You know, he was broadcast nationally on American television. The code of ethics. Yeah, I mean, it's honored in the breach often enough. Fair. I mean, you know, we are merely humans trying to. I think, in general, what a lot of people are talking about is ideological bias that is very difficult to overcome just with goodwill. You know, it's an inherent problem in journalism. That's why 67% of Americans think that any American journalist is politically biased, and that's within the United States. Is there an answer to this? These are very difficult, inherent problems in the field of journalism. And the only thing I can say is what the Europeans earlier said about, our colleague from Germany was talking about training and instilling a culture of good journalism, of accuracy. Now, accuracy doesn't mean it doesn't have ideological bias. You can be accurate about the number of dead and say they're kids instead of soldiers. You know, I mean, these are very real problems. And I don't say they don't exist. They do, absolutely. News distortion. Yeah, I think the problem is, as you mentioned about, we'll mention the Molotov cocktail throwers and not the 500,000. You know, there's an old adage in American journalism, unfortunately, it says, if it bleeds, it leads. You know, it's usually not even defined by that. It's usually defined by what pictures were, you know, where was the cameraman? And you know, unfortunately, there's some very real limitations on on reporting. To go back to the slap, I don't feel confident as I said in my talk, I don't really know about it other than the fact that it exists, and I was looking it up and talking to people about it, but I think it's better researched, or maybe you can talk about it, but I just wanted to mention that it existed as a concept. Just working. And what's the definition of, oops, I can't read my own handwriting, obscene versus non-obscene, and the definition of artistic, these are judgment calls. Yeah, do you want to pull that? Okay. It's an issue that we're always trying to figure out what the line is. You know, what was the Supreme Court guy said he recognized obscenity when he saw it? Yeah, that was. It's a issue that's debated in our edit rooms all the time. Just, you know, we just did a story, I don't know, 3 weeks ago on Lucian Freud. You try to do a story on Lucian Freud without showing nudity. It is very difficult. I mean, Now, is it obscene? He's a recognized, world-famous artist. My thought is that, you know, there's a legitimate argument that can be made that this has a legitimate artistic merit. We did show. Of course, you might not want to look at it, but that's... I'll do one more and then back. The distortion, again, it's the distortion of news. Well, actually, I don't really think I have anything to add to what was previously said. You know, clearly, news in American media, we don't always get it right. I don't know any media that does, frankly. We often get it wrong by just not covering it at all. I think that's much worse, in a way. And I have to say, I didn't know this until I saw, I think it was Pew. It turns out CBS in the last 2 years has actually increased its coverage of international news by a measurable amount, by, I don't know, 15% of minutes on the evening news broadcast. I think we're doing better. Can we do better? Of course. But there is an interest in news divisions at the moment for better international coverage.
Thank you.
Let me start with your question about the different obscenity standards and international issues, and then I'll try and go back and take the other questions in turn. It is true that it is a very difficult thing to evaluate, particularly cross-culturally. The internet has made that a much more difficult problem because for the first time in history you have a global medium that can reach everywhere, and yet obscenity law is very much culturally based. There can be religious issues, and even in the United States, evaluating obscenity is based on local community standards. And it was done that way first in 1957 and then in the Miller case that Douglas mentioned from 1973, because it said that it is impossible for any decision maker to know what the standard should be in any of the 50 states. And so you're supposed to evaluate obscenity based on local community standards. It is one of the very difficult issues that the internet age has reopened, because you have not just access to everything on a national basis, but access to everything internationally. The thing about the technology that points toward a solution, and it's one that American law has kind of adopted, is that while the internet has made more information available to more people, it also has brought with it the ability for individualized control, so that each household can use filtering technology to try and restrict what is available in that household. So in effect, technology creates, as the local community standard, the household standard. Now, that's not something government can enforce, but it is something that for those who are interested and can look for those solutions, they can find a way to better tailor what's available in their households. Now, that doesn't answer the question from a local legislative standpoint about what to do, but that's at least one approach that we're trying to move toward. Now, how that affects the news, it's not an obscenity problem, it's one of indecency, which, you know, trying to draw the line between those two concepts can sometimes mystify federal judges. But the issue that Douglas was talking about of having to be more careful in his news reports is one that our indecency laws have imposed on journalists. There's an example from Washington, D.C. from last year where we saw this happen, where a woman who was visiting our National Gallery of Art became incensed at the vision of Gauguin's painting Two Women, because it showed these two women next to each other and bare-breasted, and it's a masterpiece, been painted in the 1890s in the heyday of Anthony Comstock. But she started pounding the plexiglass covering for the art and tried to pull it off the wall and destroy it because she said it was evil and very lesbian. Go figure. Not everybody has the same sense of art appreciation. Anyway, when the local television stations decided to cover this story, because of our indecency regulations, they couldn't show the art. They showed instead the art, and then they had a banner, News at 11, across, across the chests of these women. So you see ways in which the indecency regulations can have an impact on news coverage. To try and address some of the other questions that were asked, and I apologize if I don't get to your question that well because there is a terrible echo up here. You had asked the question about whether or not the FCC had withdrawn licenses from radio or television stations because of violations of the indecency rules. It is exceptionally rare. There's still always the threat of that because the law can provide for it, but we haven't seen something like that happen since the 1960s. But I will add that there hasn't been an example of a station losing its license over indecency alone. And I doubt that if that had been the only issue, that the station would have lost its license. Usually, if a station loses its license with the FCC, it's because of some kind of misrepresentation, where they have tried to cover up something, or they have shaded the truth, or they have lied to federal regulators.
But does any court have the right to suspend or revoke a license of a TV station, like what happened yesterday in Egypt, for example? Or courts has no right to do that?
That would not happen in the United States. The closest we have come is in the 1970s with the Pentagon Papers case, where, and again, this wasn't broadcasting, but the principle is the same, where the Nixon administration tried to enjoin publication of the Pentagon Papers by the New York Times and the Washington Post. The case went to the United States Supreme Court, where it held that it would be unconstitutional, even in a matter of national security or asserted national security, for the government to prohibit the publication. And even if you, actually this is a point that was raised by a couple of speakers talking about the difference between censorship and subsequent punishment. That's really an old English concept, one developed by William Blackstone, to say that it is not censorship if you're talking about subsequent punishment, that censorship is only prohibiting someone from speaking in advance. And in fact, US broadcast law still uses that definition of censorship, but in fact, for print publications and for all other purposes, since 1931, the United States Supreme Court has said that censorship involves not just subsequent punishment, but also legal sanctions on the speech that someone engages in, because after all, if you punish someone for their speech, you're creating a chilling effect. You are, in effect, violating their right to speak, whether the punishment comes before or after the speech. And do you want me to, okay. Your next question was about the difference between those media that provide subscription service as opposed to free over-the-air broadcast. That has been one of the distinctions in US law for how free the media can be. For example, the different standards that apply to cable or satellite television as compared to over-the-air broadcast. That difference exists in part because of the fact that those media are available by subscription. It also exists because they aren't licensed to use the electromagnetic spectrum in the same way as broadcast media. But both of those reasons have been used to distinguish what legal regime applies to those media as opposed to over-the-air licensed broadcasters. And again, because of that, the fact that different media are treated differently really makes the broadcast regulations seem kind of superfluous in many ways, except to the broadcasters who have to live with them. But in terms of what is available to the public, it really doesn't make much sense. Dr. Bastioni, two things. One, I really appreciated the fact that you quoted Thomas Jefferson in his letter saying that if I had to choose between newspapers and no government and no newspapers, actually in the other order, I would never hesitate to choose newspapers and no government. I think while it's sometimes nice to imagine newspapers and no government, we all know we live in the world and that's not going to happen. But nonetheless, we strive toward having a system in which newspapers and other forms of media are as free as possible. I understand that you talk about freedom versus responsibility, and I think there are legal structures that impose responsibility on broadcasters, but more importantly, and I think this is far more important than the legal regimes, there are standards of ethical journalism that I agree, when people talk about news distortion, not everybody lives up to those standards, but I think the more media outlets you have, the more competition you have, the more the fact that you have individuals free to use the media because of the internet, the more of a check you place on the ability to use that. And I'll give us some examples in a little bit. Illiteracy, I agree, is a terrible issue, and I think you know, not just in Egypt, but elsewhere, and not to the extent as you've described in Egypt, but it's certainly a problem in the United States. It's something that we must address. I see that my time is up, but let me, if I can add just sort of a concluding remark, because I do want to talk about the news distortion issue, and this ties into what I was just saying. The problem of news distortion is one that will always be with us. Something that my wife and I do that I think is a sort of a solution to that, or at least it certainly helps with that, is to watch a channel, Link TV, that has a program called Mosaic that will bring the newscasts from all over the region, particularly in the Middle East, so you'll see the different national perspectives on different stories. I think watching any one report probably doesn't give you the whole story, but watching all of them, particularly watching them side by side, will show you stark differences in the way they are covered. And it's not just Western media that may leave things out or may have a particular perspective, but all of them have their own point of view. I think seeing more and more of them is really the solution to that. It's not something that I really see as something that government can solve. As Douglas mentioned, we do have news distortion rules at the FCC. They exist in name only. They're never really enforced. And part of the problem is, who's going to make that judgment, and who are you going to trust in government to choose which news is distorted and which news is not? It used to be that people would complain about the liberal bias on the media in the United States. Now you hear liberals complaining about the conservative bias of Fox News and of the corporate media. Frankly, you can get that complaint from all sides. I just got a bumper sticker that I gave to a friend recently that said, for comedy, Fox News. For news, Comedy Central. And it's one that frankly, I would rather watch Jon Stewart and The Daily Show than just about anything on Fox News. And I think it is. Getting those different perspectives is the way to address this issue, rather than to have someone who used to be fills the position I used to have, trying to be the referee and decide which news is accurate and which news is not.
شكرا جزيلا. Thank you. شكرا جزيلا السيد روبرت كان وريفير والسيد دوغلاس سميث. احنا متأخرين ربع ساعة عن الغداء اللي هو في الناحية الثانية من القاعة، عشان نرجع الساعة 4 هتبدأ الجلسة الثالثة والأخيرة. بس أفكر الدكتور بسيوني توماس جيفرسون قال الكلام العظيم ده عن الصحافة قبل ما يبقى رئيس، لكن بعد ما بقى رئيس وتقاعد كان بيكره يقرأ حتى أي جورنال، فخد بالك من العملية دي. شكرا جزيلا لكم جميعا.